Hello everyone, today I'll be talking about the recent Supreme Court judgment of State of UP versus Mcdowell and Company Limited. In this case, we will be discussing about Act of God. So first we will understand what do we mean by Act of God. So if any damage, loss or injury is caused on account of operation of natural forces or phenomenon such as heavy downpour, storms, floods, heavy rainfall, earthquakes, tsunami, droughts, etc., then such instances can be termed as an act of God. So when we say an event is an act of God, then we should first check that there should be some natural force involved in it. And it must be an extraordinary occurrence, an occurrence that was not in the hands of man or that cannot be foreseen, which could not be anticipated, which was not in anyone's hand to control it, and it was totally because of natural sources. It should be a natural phenomenon which is not in the hands of man or which is not the result of a man's act. So if such an event happens, then we can say that it is an act of God, and it acts as a defense in many offenses, that whatever happens is the result of an act of God, and due to which it was not in our hands, it was not our fault. Now, in the present case, the bench comprised of Justices A.M. Khanwilkar and Dinesh Maheshwari and Krishna Murari. So, in this case, in 2003, a fire incident took place in a go down of the distillery of the Mcdowell and Company, and as many as 35,642 cases of Indian made foreign liquor of different brands got destroyed in this fire. After receiving the initial reports that the fire possibly took place due to the short circuit of electricity, then the revenue department proposed to recover the amount of excise duty lost due to such destruction of liquor from the company. So they saw that it is due to the short circuit, then the company is responsible for paying that amount that was lost. Now, this credit petition was filed by the company, and the Allahabad High Court quashed the demand notice issued by the department. And finally, the appeal was filed before the Supreme Court, the Apex Court. Now, the Supreme Court observed that a fire accident cannot be said to be an act of God if it did not happen due to the operation of any force of nature. So here they are saying that it might be a short circuit, and Supreme Court also explained that what can be said to be an act of God and what cannot be. So the Supreme Court clearly said, the bench clearly said that act of God, for act of God to happen, it is necessary that it should happen due to any force of nature. And when nothing of any external natural force had been in operation in violent or sudden manner, then the event of fire, which is there in this case, which is in question in this case, could be referable to anything but to an act of God in a legal parallel. So it cannot be said to be an act of God, and this event, this particular fire event cannot be termed as an act of God, and it was finally held, which is the most important. The judgment given by the Supreme Court was that fire accident can't be termed as an act of God if it did not happen due to external natural forces. So this is all about this case. I hope this video was helpful to all of you. Please do like, share and subscribe to my channel. And in case you have any query in relation to law matters or law exams, you can reach out to me on my email ID or on my Instagram ID. The link for the same is provided in the description below. Thank you very much.